What's going on, everybody? TRAE4PAY back in the building, coming at you guys with part 3. I think we're on part 3 of day 9 of the Darrell Brooks trial. I just want to tell you all really quick, there will be one more part for day 9 coming out tomorrow. I'm gonna post the end of it. The reason why I wasn't able to finish day 9, I put up in a community post that recently I got sick with the flu, so I was able to record some footage, but then I had to get some rest. I'm gonna upload the final part, which will be part 4 tomorrow, so you guys won't have to wait a long time or anything for it. Thank you all so much for sticking with me. Thank you for all the well wishes from everyone. I saw a lot of people commenting and told me they hope that I get better soon, and I really do appreciate that. Thank you. So really quick, I want to say thank you to everybody that donated. We have quite a few donations this time, so if you see me looking over here, that's what I'm reading off of my notes. I want to say thank you so much to Digi Goodness for a $5 donation. I really do appreciate it. I know you've been around for a long time and you always leave like really encouraging comments for me. I really do appreciate that. I appreciate all the encouraging comments I read, so thank you so much. I want to say thank you so much to Ali B for a $10 donation. I really do appreciate it, and thank you so much for watching along. Thank you so much to Tina P for a $10 donation as well. You said look out for when Darrell uses the word badger when I think you were saying when they show him the parade footage, when they confront him with it, so I'm gonna definitely be on the lookout for that. Thank you once again to Joan Coles for a $10 donation. I really do appreciate it, and thank you for all the nice comments you leave as well. Everybody that's on this list, I've seen your comments. Thank you so much for all the encouraging comments you leave as well. Thank you so much again to Ms. Rebecca Reams for another $10 donation. I really do appreciate it. Your comments are among all the ones that teach me a lot of stuff about how the legal system works, a lot of the terminologies and the things that I just have no idea about. I really do appreciate it. Thank you once again for still watching along and for sticking with me as well. Thank you so much to Vicky Bramlett for a $10 donation. I really do appreciate it, and thank you so much for sticking with me and for watching along. Thank you so much again to Becky for a $25 buy me a coffee donation. I really do appreciate it, and thank you so much for the kind message you wrote as well. You said you were doing your good deed for the day, and I really do appreciate it. You recommended that I get a P.O. box. I probably will, you know. I'll go ahead and get a P.O. box started at some point. Never had one before, so I'll have to look it up and see how to do it. Thank you so much for that, and I really do appreciate it. Thank you so much to Joy for a $15 buy me a coffee donation. I appreciate it, and thank you so much once again for sticking with me and for watching along. And then there was one donation that was anonymous, but it was a $5 buy me a coffee donation. So thank you to whoever you are. You know, I appreciate it. Keep sticking with me, for watching along. Thank you to everybody. I really do appreciate it. But you all know what I'm gonna say. No one has to send me a single thing. But if you would like to donate directly to the victims and the community of Waukesha, there are links pinned at the top of the comment section. So if you're looking for resources to do that, it is right there for you. Okay, this is a super long intro, so thank you so much to everyone, and look out for part 4 coming up tomorrow.
The record in State versus Brooks appearances are as they were before. Just want to make a quick record. It's not something we need to address right at this moment. I provided to the parties the pattern jury instruction 152 related to jury view, and then an instruction I drafted based on that. And I say based on that because this has to do with the view of the vehicle, because I view a view of a scene differently from a view of a vehicle, which is evidence. So again, we don't need to go over this now, but I at least wanted to give those to the parties so that when the appropriate time comes, we can discuss whether the court should say anything regarding the view of the vehicle, if that is in fact still the request of the state, and then if so, what that should be. So I've provided that to both the parties in written form. Go ahead.
Judge. Actually, I appreciate that, and I wanted to bring this up this afternoon so we can plan. Obviously, I don't know if the mics are on.
It should be, yes.
Okay. I'm soft-spoken, I'm sorry.
Said no one ever. Oh, that was all loud, sorry.
So, with the court's permission, we would like to schedule the jury view to occur at 12 noon tomorrow. Now, we may not be through testimony at that point with the state's case, but like we did with the interpreter, if we could get a commitment from the court to pause whatever we're doing around 11:45 or 12 noon tomorrow and lead the jury to the location for the jury view. There's obviously some planning that needs to take place by the sheriff's office. The tow truck needs to be arranged, and I believe the maintenance division needs to assist in some way as well. So what I'm learning is that it's best if we just pick a certain day and time and set it, and then, you know, again, with the judge's permission, kind of work around that in the courtroom. So that is our request, if the court is willing to accommodate that.
In regard to that request, I know I had internal discussions with the sheriff's department because they're in charge of security over the trial, and I don't frankly know how much we've talked about this previously, but it is in a secure location, or will be. I've made arrangements, or I've instructed the sheriff's department that because of the location that we will be in, it's not something that will be that anyone can just follow us to, but contemporaneous recording will be made and then placed into the record so that the public is aware of what happened, but after. So I did want to add that to the record.
I completely forgot that also is a thing. So apparently, I feel like somebody reminded me of this very early on. The jury is actually going to be able to look at the vehicle because it's evidence. So they're going to be able to actually go up to the vehicle that Darrell used in the parade, and they're going to be able to view it.
In terms of the request, Mr. Brooks, this relates to the viewing of the vehicle that was recovered by the Waukesha Police Department. There were preliminary discussions when you were still represented by counsel, and the request is being made that the viewing of this vehicle take place tomorrow. Your response, if any?
First of all, I accept
for
value in return for value this paperwork. I guess I'm still confused as to why there needs to be a jury view.
I can have the state put their request on the record again. I'm responding to their request. So go ahead, Attorney Opper.
Yes, Judge, and I believe the court has already approved this request. A motion was filed and ruled on by the court previously, but as Mr. Brooks has been charged in every count with acting while armed with a dangerous weapon, we believe it's relevant and appropriate for the jury to view what we're alleging to be the dangerous weapon in this case, that is the 2010 Ford Escape.
And once again, Darrell thinks that because he doesn't know what's going on. I mean, he understands even this something is, you know, it's the actual vehicle that he used. It's the SUV itself. So it makes sense as to why they would want to see it, you know, in terms, I mean, this whole trial is around him using this vehicle to harm dozens of people. So it makes sense, but, you know, he's going to pretend as if he doesn't understand, and hopefully that, or he's hoping that gives him room to get out of it. Of course.
It's essentially,
didn't really
would be no different than bringing a firearm into the courtroom during a shooting case.
Right.
And I would just simply note the first-degree intentional homicide and first-degree recklessly endangering safety charges are what carry the enhancer for use of a dangerous weapon. Of course, the hit and run does not have that enhancer, nor do the bail jumping and batteries. But with that caveat.
Yes, thank you for that correction, Your Honor.
All right.
Here comes Darrell. He wants to argue about something.
I'm confused to that too. Why are there only certain charges that have an enhancer?
Well, the court's not going to answer that, sir. Those just happen to be the charges. The state is tasked with proving each one of those charges and any special verdict question that goes along with it. Beyond a reasonable doubt, they bear the burden of proof, as was spelled out in all of the preliminary jury instructions. So that's how I'll answer that. In terms
Should've kept
of
this
the jury
attorney.
view, I did grant the motion previously. It was unopposed, and I'm not hearing anything that would cause me to reconsider that. In terms of the time that's being requested, do you have any position on that?
Do I have to be present for this?
I would like you to be, and yes, we're making arrangements for you to be there, sir.
Do I have to be present for it? And also, for the record, I don't consent to the name that's being referred to.
I'll use this opportunity, sir, to ask what name you prefer to be called, because we now have evidence in the record where you provided your name to, upon questioning. There was video from when you were taken.
Hold on, I just want to say, do you see whoever this is back here? As soon as she asked that question, I mean, I can't tell if he's smiling or not. He might just have a normal facial expression. But it looks like he started smiling as soon as she asked that, which is like... But, okay, I just want to hear what he's going to say about this.
Upon questioning, there was video from when you were taken into custody, and then, of course, Detective Carpenter has testified about that as well. Again, I try to refer to the parties by name because that is how I believe I demonstrate respect and decorum in this courtroom. And we've been given no other name, sir, by which to call you by. And I must, at that point, go back to what's on the criminal complaint, which is the initial charging document. That is what was filed in order to initiate the case.
With all due respect, the record should be corrected. I didn't put anything on the record that was...
I didn't state that. I said there's
said
evidence in the record.
Well, evidence, what you referred that evidence to me.
So there's evidence in the record, but be that as it may, I'm just letting you know I'm going to keep referring to you sometimes as defendant, sometimes as sir, sometimes as Darrell Brooks, sometimes as Mr. Brooks. I understand you may still have an objection, but I've been given no other name from you by which to call you.
I follow, but there's still a lack of understanding. Are you referring to the name that was in all caps on all the filings?
Of course,
Because
not
every
gonna answer
filing that I
sir.
have,
I find the response to be kind of disingenuous, sir.
So there was
This is, I believe, a tactic by you
Yes.
to create some type of confusion, which I don't believe there is any, about who you are and what name I need to refer to you as.
I never said you had to refer to me by any specific name. That's not what I'm saying. I'm saying that every filing that has ever been filed was in capital letters. That's a fact. I have paperwork to prove that.
Oh my goodness. So okay, so he's diving a bit deeper into the name thing. So apparently his name being all caps is a reason why they can't refer to him. I mean, look, she said it just now. This is simply just a tactic, you know, to cause some sort of confusion. It's a bad one. I mean, we've discussed this already, but it's like, yeah. I
don't recognize that name, nor do I know any individual by that name. That's all I'm stating.
Well, let's assume for a second that it's not in all caps. Do you recognize that?
No, I do not.
Okay, well,
Because
we have our answer then. We're going to keep going, sir. We're a little bit off topic. In terms of the request by the state, I'll give you one more opportunity to answer that. They've requested that whatever we're doing tomorrow morning, whether it be their case, whether it be if you are calling witnesses, that we pause about 11:45 in order for the jurors, the court, and the parties to be taken to that secure location for that jury view. Do you have any position as it relates to that?
Yeah, my position was, when I answered, I said, do I have to be present?
I'm requiring you to be there, yes.
And what reason do I have to be present?
Unless you're willing
She said so.
go through a colloquy with this court and intentionally waive your right to be there, because then I'm going to require you to be there.
And that's not explaining why I have to be there, though.
Because I'm requiring you to be there, sir.
And you just made that decision now?
All right. He's not answering the question that I asked him. We will pause
I'm
at
trying to get
approximately
understanding, that's all.
11:45 tomorrow morning for that jury view of the vehicle to take place as soon as we're able to walk over there. But I think given the logistics of everything, it is on campus, but it is in a secure location. That will take place approximately at noon. And as I indicated, the court will require the sheriff's department to make a contemporaneous video of that view, which will subsequently be made part of the record to capture that.
Okay, I'm sorry I'm pausing so frequently, but that moment just now. So I'm glad we had a little moment like that. Once again, where it's like she makes a decision that Darrell, like, he doesn't want it all, but he has no choice. He has no option. Just like when she orders him to be taken into the other courtroom. It's like in those moments it almost breaks his spirit a bit. Just like in the times where like they pan the camera over to that room and then he's crying his eyes out because he has no choice. And then, he hates when a woman pretty much has power over him. So in these types of situations where it's like she makes a decision that he has no choice whatsoever, I feel like this is going to cause him to have a tantrum right now, which is why I wanted to pause really quick, just, I guess, basically throw that guess in the air. But let's see what happens.
Don't I have rights, though, Your Honor?
All right, then with that,
Could I ask another question?
Go ahead.
Scheduling, Your Honor. Could you please indicate your intentions as to how late we will proceed this afternoon so we can line up witnesses?
sure, I'd like to try to, we had a little bit of a long day yesterday, so I try to balance that out for the jurors. So generally between 4:30 and 5 is when I would like to break, depending on where we're at. If we need to go a little earlier because of the witness, or if we need to go a tad later, that's fine as well.
Okay. And then the last item, Your Honor, is that, to my knowledge, we still have not received anything from Mr. Brooks as to the date and time when he would like his witnesses ordered to appear. I don't see anything was e-filed. So if he is still requesting the assistance of the state to secure the appearance of those witnesses, we will need that information, Your Honor. He does not have to give us the exact order, but if he could tell us, as you had suggested, either morning or afternoon, and what day of the week he wants these people here. We have served the subpoenas that he requested at his request in order to assist him. And these witnesses obviously have jobs and other commitments, so it's reasonable to be able to give them a time frame on when they need to be here.
With that, when do you expect to rest?
We're still hoping to rest by the close of business tomorrow, Your Honor, unless something unforeseen happens.
Oh man, Darrell does
So we're
not like to
talking
hear
about
that.
Thursday and Friday at this point.
Yes.
Which is what I suggested from the beginning yesterday.
But Mr. Brooks, we need to know which particular witnesses on which day and whether it's AM or PM. Don't need to give me the order. We'll have them come in groupings, but it's not reasonable that they all come on the same date.
I never said it was.
All right, so you need to provide that to the DA.
How am I supposed to provide that to the DA?
You can write that down, or you can put it orally on the record right now. I asked you to bring it with this morning, and I didn't cover that this morning, so you were put on notice of that. But I'll give you until...
I was put on notice of what?
Let me ask Attorney Opper a question. Would tomorrow morning first thing be sufficient for the state to make those arrangements, given that you don't believe you will close your case until the end of the business day tomorrow?
I understand what the court's saying. I think that's reasonable. With the understanding that if somebody needed to give notice to an employer and it can't be accommodated, then that may affect things for Mr. Brooks. But I think 24 hours notice is generally reasonable, and we will do our best. We can assure the court we will do our best to get them here, but I don't know if we'll be able to exactly accommodate the timing that he may or may not want.
All right, so Mr. Brooks,
Objection to that because
He's just trying to play with people's lives right now. He does not care
served to
whatsoever.
them. I'm assuming that they would have let any employers or anything know that they were expected to testify in a trial. I don't understand why it will become a problem at the last second.
well, if you recall, sir, at the end, near the end of last week, I don't recall exactly what day we were on, but we knew we weren't going to finish with the state's case at some point, and we had a discussion on the record. If there was any objection by you, if the state told those witnesses they didn't need to appear on Friday, so it obviously had to have been before Friday, that they didn't need to appear and that they would work with those witnesses to provide them with a more definitive time. So now is the time when we need to provide them with more definitiveness. So by the start of court tomorrow, you need to bring with you, either in writing or be prepared to put it on the record orally, which witnesses you want. We'll start with Thursday morning,
He's not
then
gonna do it.
Thursday afternoon, Friday morning, and Friday afternoon. I don't need to know the order, but I need to know the day of the week, right? So Thursday or Friday. I would just note the dates for those. Thursday is the 20th, Friday's the 21st, and then which witnesses. Only you know how much you want to question them, so you should be able to gauge if we can get 2 in each morning or afternoon, 3, 4, whatever. Use your best judgment on that.
Yeah, I don't know how I'm going to come up with exacts on that.
I presume you're going to prepare some questions and you might be able to kind of gauge how quickly that will go or not. If not, we'll do our best, but you've got to provide some definitiveness. It's not reasonable to just have these witnesses all come on one day.
I wouldn't be surprised if he shows up with no list tomorrow. I'm pretty sure he's just gonna show up and say that he felt like it wasn't necessary or something like that. And in his mind, that's gonna just throw everything out of whack, and everyone has to scramble to fix it. And well, it's gonna take us some time to fix this now. That I feel like that's what he thinks is gonna happen, but they're just gonna move on. They're gonna move on without him. And honestly, I'm kind of hoping that's what happens, just so he has that spirit breaking moment again, where it's like, oh, you didn't bring your list? Okay, well, your witnesses are null and void, and we're just gonna continue with what the prosecution wants to do. But yeah, I just got a feeling that's what he's gonna do.
I'm informed of what you're saying. I just feel like that same courtesy wasn't afforded to me by the prosecution. They didn't have to tell me exactly what witnesses was being called on what day and all this and that. Why is it not
I am requiring it, sir, because they are assisting you, because they graciously agreed to do that because you are representing yourself. If you want them to be out of the loop on that, then I can just put it on your responsibility and your shoulders. But that is up to you.
What do you mean by put it on my shoulders?
You can contact them.
How am I supposed to do that?
You have access to a phone in the jail.
This is ridiculous.
So I'm supposed to call everybody that I subpoenaed, not knowing their information?
That is one way to do it, sir. Their information is in the police reports.
That is highly unreasonable. When one person that's on my witness list, I'm not even permitted to have contact
That
with.
would be a good exception to that. So that's very astute of you to point that out, sir. That would be one exception. But other than that, in any event, sir, we're kind of a bit off track. We're going to get back on track, and you need to provide the information that's provided, that I've outlined here today.
I don't think that's fair, Your Honor.
Oh, your objection is noted, but it's my ruling.
The state didn't have to do that, but I have to do that.
Sir, I remind you that you are nonetheless required to follow the rules of procedure just as any attorney would have to if they were representing you. You've chosen to represent yourself. The state has graciously agreed to assist. They've served the subpoenas on your behalf. They didn't have to do that, but they did. They've agreed to contact the witnesses throughout so that a better idea can be provided to those witnesses as to when they need to testify. They're simply asking for some basic courtesy so they can then relay that information to the witnesses you want to call in this trial.
I'm informed of that, Your Honor, but
all right, then let's move on.
That's actually under the confrontation clause in the Sixth Amendment. I should be able to have the right to have witnesses subpoenaed. It shouldn't. Why is that?
Again, we're getting a little far afield here, sir. Subpoenas were provided to you. The record is very clear on that. We assisted you with that. I even reviewed them for completeness. And then the state assisted you with serving them. That is something they are not required to do, but they agreed to do in this case. So nothing about your Sixth Amendment has been violated in that regard.
Did I say violated or did I say I'm not?
So that's you need to understand that, sir.
I don't understand anything. And for the record,
all right.
That's the truth. He just told the truth right now. This is the first time I feel like this is some kind of this is some kind of historic moment. He just told the truth. He doesn't understand anything. But no. I was just gonna say, so I've been sick for the past week, and it's like every time I step away for a little bit, I clear my mind. I don't think about this guy because I don't want to think about him. And when I come back, it's almost like a shock that you feel initially when you hear him talk and the way that he's speaking to people, and they're just asking him these simple questions, and he's, for some reason, he just won't give an answer. He won't give a definitive answer or just a simple answer to these questions. A simple answer to simple questions. He knows exactly what's going on. Anyone in this situation right now, the way that she broke it down, the way the prosecution broke it down, it's not difficult to understand. Just tell us who you want on this day and, ballpark the time or whatever. But yet, he's pretending like he just doesn't get what's happening. And so it's as soon as I came back here, it was that it's just a shock every time, and pretty much every time I record one of these, I have that small moment. But here we go. Let's continue the tantrum about nothing at all.
Bring up the word
let
violated.
Us continue then. We're going to move on, Mr. Brooks. Let us continue with the questioning.
So we're going to move on to subject matter jurisdiction that has yet to be proven?
Detective Carpenter, you can please come on back up to the witness stand, and Madam Clerk, you can have the jurors brought out.
So we're not going to address that at all? That's not going to be proven for the record?
He runs back to that every time.
Is that a judicial determination that you don't have to answer the question, Your Honor? Is that also a tactic agreement?
The state would move exhibit 82.
A tactic agreement as well.
All right, you want to do that in front of the jury or just with me?
I wasn't sure if the defendant would have any objections that would need to be heard off the record or outside the presence of the jury.
Well, can you have
I'm so glad she's ignoring
Do you have any
this one.
objection to Exhibit 82?
Yeah, I got objection.
What's the objection, sir?
What is the relevancy of Exhibit 82?
82 is your interview with Detective Carpenter and Detective Stern. Your objection is to relevance? Your objection's noted, it's overruled, and I will receive Exhibit 82.
There you go.
Let the jury know that when they come
So
in.
are
Yes.
you overruling the fact that the true nature and cause has not been presented to me, that I don't know what the true nature and cause of the charges are?
That's a personal problem. That's a personal problem right there.
You can have them brought out now. All right, thank you.
It's amazing to see in those situations. As soon as he's ignored, he sits quiet, you know.
Your Honor, may I see a sworn affidavit of the nature and authority of the court?
Uh-oh, we got a last resort effort
Or
here
is
to
that a
get kicked
judicial
out.
determination? You won't answer that as well.
Welcome back, ladies and gentlemen of the jury.
I hope the record reflects that.
But here we go. Detective Carpenter's coming back out.
All right, thank you, everyone. Please be seated. Record will reflect that Detective Carpenter is back on the witness stand following the break for the lunch hour. And Mr. Brooks, you may start your cross-examination.
I don't consent to being called that name, Your Honor.
Your objection's noted. It's overruled. Please ask your
Can't be
questions.
overruled. Detective Carpenter.
Why did he say his name like that?
Did you attend the parade that evening, November 21st of 2021?
Yes,
In what capacity?
as a member of the Honor Guard.
And what time did you arrive?
I don't recall the exact time.
What time did you leave?
I don't recall the exact time.
And when you left, where did you go?
Our temporary police department.
Temporary. Explain what do you mean by temporary?
So at the time of the incident, the building we are in currently, which was our main building, was under construction. So we were displaced.
What do you mean by at the time of the incident?
At the time of the parade.
And so the regular station was, what did you say, under some type of construction or something?
Correct.
And so what were you guys using for the temporary police station?
The city annex and city hall. We're in two different buildings.
Does any of those buildings consist of a room for interrogation?
There is at the annex.
And so when you initially interrogated the suspect, why was the annexed interrogation room not used?
Well, when I interrogated you, Mr. Brooks, the annex room was not used because the situation was very fluid. There was a lot of information being learned. We knew this was going to be drawn out. There is no municipal lockup facility at the annex, so it could not be utilized.
And so the police holding room in the hospital was more sufficient.
You asked to go up there for medical clearance.
So the police holding room in the hospital was more sufficient than your temporary station, which would have been more suitable.
Yes, it was more sufficient.
And why would a hospital police room be more sufficient than the actual police station that you were utilizing at the time?
So the questions are already irrelevant. None of this
As I
matters.
stated in my previous testimony, there was no secure lockup facility at the station. In addition to that, you requested medical clearance at the hospital.
So was there sufficient lockup at the police room in the hospital?
We had areas in the hospital, so when you were being treated by the doctor, you could be handcuffed to a bed. There is no place in the interrogation rooms you referred to at the annex to handcuff you to anything, and the doors did not lock sufficiently.
And to the best of your knowledge, would a detainee have that information that you just stated?
No.
So
He's
how
got the
come
gears turning.
the suspect couldn't be handcuffed at the annex for the interrogation without having to be handcuffed to a specific bench or whatever you refer to it as?
Well,
I guess essentially what I'm asking is, could the suspect
What are these
still
questions?
be properly detained while being interrogated at the annex versus the police holding room in the hospital?
so let me make sure I have this straight. Your question is about detainment. Do I have that right?
I think the question was very clear, Detective.
I can't answer it if I'm not going to get clarification.
He just wants to argue right now. I knew that's pretty much what was going to happen as soon as he came. As soon as they got to the cross exam.
And where was the suspect taken upon being detained?
You were taken, Mr. Brooks, upon the time you were arrested, down to the substation on Les Paul Parkway in Waukesha.
And do you recall if the suspect was put into a holding room?
Yes.
And do you recall if that holding room had something that would secure a detainee?
Yes.
So why couldn't the interrogation happen there if the suspect can be secured at that location?
Well, there are various reasons, and one of the most important reasons is when we took you to the hospital, Mr. Brooks, for your medical clearance, there were now a total of 4 officers there, myself, Detective Stern, and eventually the 2 federal agents. The situation was still very fluid. When I began the initial the initial questioning, it was 11:04 p.m. and there were still a lot of unknowns. So the determination was made to start questioning you, see what information you might be willing to provide us, because with 4 of us, we were confident we would be able to keep you where you belonged, where we needed you to be, as opposed to risking another unnecessary transport. Because and it's not just personal against you. Any transport of any prisoner, there's a risk. So there's no point in taking that risk of that transport when we had the ability to do the interview there, especially when there was such limited information that we had.
So FBI agents were present at the substation that you referred to?
They arrived there at one point, yes.
Was that known to the defendant?
I don't recall.
Why does he think he has to be informed?
Is it fair
of all
to
of
say
these
that
things?
the detainee could have been Is it fair to say that you could have made sure the suspect was contained while at the substation, seeing as how that there was multiple officers present?
Objection. I think this has been asked and answered.
I think he's referring to the substation versus the hospital, so I'll allow
He
it.
definitely has. I don't even know what he's getting at, though. It's like,
You were contained initially at the substation, Mr. Brooks. But you requested medical transport, so you were transported. So what I'm explaining to you in my prior testimony is I didn't know at that point if you'd end up going straight to the county jail or what have you. Every transport, as I stated in my earlier testimony, there is a risk. There is a danger. It's not just personal to you, it's any prisoner. So the decision was made to start the interview there based on not knowing where you'd end up for sure, not having all the information, that we weren't going to take the risk of an extra potentially unnecessary transport back to that facility. You couldn't be held there. You couldn't be held at the sub. There's no beds.
You referred to interrogation starting at a specific place. I'm referring to the substation. Is it fair to say that there was no interrogation that took place at the substation?
Yes.
Yes, that's fair to say?
There was no interrogation at the substation in Waukesha.
Do you recall what information was obtained at the substation?
Yes.
Do you recall what that was?
Yes.
Can you state for the jury and for the record what information you obtained at the substation?
Yes, sir. Basic biographical information. So I obtained your first name, Darrell Brooks, your last name being Brooks, your full middle name, I should say, being Edward. I learned that you were a junior. The date of birth, February 21st, 1982. Additional information obtained was your home address, which was you provided as 4014 North 19th Street in the city of Milwaukee. Phone number, your emergency contact, which you provided as Dawn Woods, whether you were employed, going to school. I remember talking with you about your tattoos and other physical marks that might be on your body, your hair color, eye color, photographs were taken.
Why would Darrell ask this? Why did he just ask this? This is a terrible question that backfires so horribly for him. But by the way, I wanted to say thank you to someone mentioned that his job that he talked about was actually fake. I had no idea. You know, I didn't look into his work history or anything. So thank you for that. I guess he's referencing like the 8 Mile movie or something like that. But basically, the job that he was explaining he had during the interrogation is completely fake.
Kept mentioning that name. Pretty slick.
That's slick.
Sure, disregard that last statement. Sir,
That's
please
so
ask questions.
unexpected.
You'll have an opportunity to testify later.
Oh, I got a lot of questions.
Oh, boy.
And at that point in the investigation, what did you initially know?
At that point, we knew that the red Ford Escape had driven through the parade route and that you'd been identified as a suspect.
And why was that information not provided at that time to the detainee?
The information at the time wasn't presented to you, Mr. Brooks, because, as I stated in my earlier testimony, it was still very fluid. It was very chaotic out at the scene. There was still a lot more that needed to be learned.
So is that standard procedure to not tell a person why they're being detained?
Well, we didn't not tell you. That's incorrect, and it's misleading to the court. You were informed you were being detained for prowling, loitering, disorderly conduct of that nature.
Is that the same as...
Can I finish, please? I just didn't bring up the parade part of it.
Why not?
As I stated in earlier testimony, it was very fluid and chaotic, and a lot of information wasn't yet known. So I was waiting to receive more information.
Did you state in your early testimony if that was standard procedure or not?
It's standard.
So with every detainee that you've ever detained during your career, 18 years, right?
Yes.
It's standard procedure to not tell someone being detained what they're detained for.
As I had stated in my earlier testimony, Mr. Brooks, I explained to you you were detained for prowling and loitering and disorderly conduct. Based on the lack of information on the parade, that was not brought up. So what I can clarify for the court at this point is that in situations where so limited information exists early on, it is standard not to convey that information to suspects.
And what do
Darrell
you mean
really
by
thinks-
is standard?
He thinks he has them cornered right now. That's probably the most
I
hilarious
mean that
part.
I don't tell them because I don't have all the facts yet, and I'm not looking to necessarily accuse them before I know the nature of what they did or didn't do exactly pertaining to that incident.
So it'd be fair to say that it was not a fact as far as the information you learned to that point in the investigation.
Objection then.
Grounds.
Sustained is to the form of the question.
So at that point in the investigation, it wasn't a fact.
Objection, same question.
Grounds.
Sustained is to the form of the question.
At that point in the investigation, the information you had at that time, you weren't sure about.
I guess which part?
All the information that you had up until that point.
Okay, about the prowling or parade, I don't understand which part of it you're talking about.
All the information
He doesn't
that
know
you've
either.
obtained at that point in the investigation, you weren't sure about. As you just said, you don't try to assume guilt or anything like that until you have all the facts. So at that time, at that point in the investigation, is it fair to say that the information that you had obtained so far, you were not sure about?
I wasn't sure if you were the driver initially, but it was believed you were involved.
And you knew that to be fact?
Yes, the information being provided was that you were involved.
So it'd be fair to say you knew that as a fact?
Well, hold on. I'm going to not allow him to answer that. This jury will determine the facts of this case. If you want to ask him his opinion, you do that at your discretion.
He said fact. He said facts.
You asked the question, sir. So
He brought it up first.
I'm going to strike the question from the record. And Mr. Brooks, you're directed to rephrase.
I will rephrase, but I do not consent to being called that name for the record.
Noted.
You called
in the
yourself
rules.
the name, so we don't care. You called yourself this name. This is ridiculous now. It's starting to get... It's entering the cartoonish territory once again. We're getting there.
You stated that there were some loitering and prowling allegations. Why? To your knowledge, were those ever charged?
Objection relevance.
Grounds.
Overruled. The witness may answer.
No.
And do you recall why not?
No.
Any follow up on that, or?
So why did you constantly tell the detainee that they were being detained for loitering and prowling if you in fact knew that there was another reason why they were being detained?
Objection asked and
Grounds.
answered.
Sustained. That's the form of the question and assumes facts not in evidence.
You know what's insane? Pretty soon here, if he asks like maybe one or two more questions and she sustains them, then he's gonna turn on the judge because he just wants to get this argument going right now. Like, he's itching to argue with this guy. He's been waiting to do it ever since he got here. So if she sustains his question like one or two more times, then he's just gonna turn and start arguing with her at that point because she's getting in his way, in his mind, of like him getting at this guy. But like, this is gonna be, I know it's gonna turn into a tantrum because he can't get this guy. Like, he's trying so hard. Now, you saw the way he started. Oh, I have a lot of questions, and it's like, dude, nobody's scared of your questions. You ask these weird, like, he just asks things that make no sense, but. Oh no, we've slowed down again.
What was the significance of the FBI being present?
The significance of the FBI presence was the early on concern that this was a terrorist-style event.
And you said that this was a terrorist element. And what is the this? Can you explain what the this is?
When you drove your vehicle through the parade and struck people.
Which at the time you stated you did not know as fact, correct?
That was still being investigated, yes, but I know that's what occurred now.
Now versus
Okay,
then.
I'm not gonna pause yet.
Initially, it was unknown if you drove.
That's what I was
stated.
That was the question.
But the investigation showed that you were the driver of the vehicle.
So what does he think is supposed to work? How does he think this works? They're not supposed to investigate it unless it's like definitive, like, I don't know, I don't know what he thinks, how like an investigation works. Like they receive information, but okay, we can't act on that. We don't know if it's true or not. You know, we don't know if that's true, so we can't investigate it unless like it's actually, like, what does he think gives them a reason to investigate something or to just like figure out if something actually like, I don't even know how to word what I'm trying to say. It's weird to like try to actually dissect these weird arguments that he has. Like even I have trouble trying to like, because it's so weird that it's like your mind doesn't even go to those types of places, but of course his does.
And initially you didn't provide that information, correct?
Correct.
So do you know if the FBI continued their part of the investigation?
Eventually, the investigation was strictly run by our department.
And do you recall why that decision was made?
My understanding is there wasn't a terrorism link.
I'm sure throughout your career you've done lots of interrogations. Are there usually multiple officers that do the interrogation, or usually just one?
It can depend on the circumstance. It's not always more than one, but it can be.
And what would you estimate would be the normal procedure for interrogation as far as law enforcement wise?
I really can't speak to that. I think every department probably has their own potential way of doing things.
Up until that point in your career,
What is he looking for? Like,
when you interrogated the detainee, had you ever conducted an interrogation with FBI present?
Not prior to that date, no.
so is that supposed to mean it's unfair for him because they were in the room, that somehow hurt him? I mean, what is he really? I'm not going to keep asking.
Made reference to car key being found. Do you recall that?
Yes, I do.
Did you yourself find the car key?
No, I did not.
Were you told by other law enforcement?
I guess told what exactly?
That a car key was found.
I was not specifically. Your items that were located on you during the search were turned over to Detective Stern, and the car key was one of those items.
And to the best of your knowledge, you didn't have that information at the time, correct?
At which time?
at the time that the detainee was detained in the substation.
Thank you for that clarification. Go ahead and answer.
I just want to make sure I guess that I understand. So you're asking me what I knew about the key, or if I knew where it was found at the substation? I don't understand. Can you clarify that, sir?
I guess the clarity that you may be looking for is what was found and brought into the substation?
Okay. The Ford ignition key and other items that I alluded to in my earlier testimony include your photo ID and credit cards with your name, or debit card, credit and or debit cards with your name on them.
That you did not search and find yourself, right?
That's correct.
Did you conduct any searches?
I don't recall if I did or not of your person.
He's uncovering so much corruption.
So it would be fair to say you don't know where certain items were found at the time that you learned of there being items found, correct?
No.
No, as in?
No, I knew those items were found on you in the search. Maybe not the specific pocket, but I knew the officers found those items in your possession.
Were you at the scene of the search?
No.
So how do you know where they were found?
Because they were turned over to Detective Stern as your property.
But you didn't see them.
How do you know where they were found, though, if you weren't at the scene?
Because I was aware officers searched you, and it's not reasonable to believe they were randomly in the grass at the house you were at in a city that you've indicated you're not familiar with.
Can you strike that last answer from the record? I didn't refer to any house, grass.
Please don't. Hold on.
You asked an open-ended question. His answer will stand. Your request is denied.
So it'd be fair to say that in the question I did not mention a house, grass, or a city? That'd be fair to say?
You didn't mention it, but I know you were found at a house in the city of Waukesha. And I know you're not familiar with Waukesha because that's what you told me when I interviewed you.
Can you strike that last answer?
Request is denied.
On what grounds, Your Honor?
Why does he
You asked
keep
the
doing
question.
this?
He answered it. If you
What's
want to
going
limit,
on?
ask leading questions and direct him.
He's falling off the rails.
You made reference to
He's falling apart right now. Here
the
we
house
go.
where the detainee was found, the grass, the city. Could it be possible that that's where they were found? The items that you are referring to?
No.
Even though it would be fair to say that you were not present.
Correct.
You made a lot of reference to the body pain and having to be checked at the hospital and being medically cleared. Would that be fair to say?
Yes, we took you to the hospital for clearance.
Are you yourself a doctor or have any training in the medical field?
No, sir.
So it'd be fair to say that you cannot know how a person's body is feeling. That'd be fair to say?
I can't explain exactly what another's body's feeling, correct.
So it'd also be fair to say that there's a possibility that you can be incorrect about assumptions made to pain reference. That be fair to say?
I think that depends on the circumstance. In this specific circumstance, you
Okay,
told me.
question, the last follow-up, if he wants it.
Okay.
Next questions.
He literally stopped holding his arm in pain and started rummaging through their paperwork. So
You made a reference on one of the exhibits. I'm not sure exactly which one it was. It was the first interrogation in the police holding room in the hospital. In that exhibit, you made reference to the FBI being present because you were short-staffed. Do you recall that?
I don't recall exactly what I said, but I recall acknowledging their presence, yes.
And you made a reference to short-staff. Can you explain what does short-staff mean?
I don't recall if I said that or not.
oh, you know
I
what?
don't know if it's exhibit 172 I'm referring to.
He's gonna ask them to pull this up.
Can you pull up exhibit 172, please?
We refer to the photo of the identifiers and the items found.
Is that 172?
172, yes.
Well, I don't think, is it 81 then I'm referring to?
81 is the audio recording.
Okay, it's
I'm
81.
sorry, 81 is the video and audio.
Of the,
Was it just the audio? I was right the first time. It's
okay, I think it's 81.
You would like the audio recording from the hospital.
Yes, Your Honor.
Is there a part you'd like to direct the state to when they pull it up?
Because it's the audio, I'm assuming it'll be probably as soon as the defendant is brought into the room.
It was played starting at 4 minutes and 25 seconds through 14 minutes and 25 seconds. Do you want it started right at 4:25?
Yes, Your Honor.
Okay. The state would please assist with that.
How long would you like it to be played?
Do you know how long you want it played, or do you want the whole thing? The
I don't-
same clip?
I don't need the whole thing played. From what I recall, the point that I would refer to is pretty early in that.
Well, how about we start at 4:25 and then you say pause, please, when you want it to be paused by the state.
Okay.
All right. Go ahead.
I'll tell you.
It's Darrell?
Yes, sir.
Hey, Darrell. I'm Jeremy Polachowski. I'm the FBI. FBI? Yeah.
FBI?
I'm Mary. Yep.
They're just kind of helping out because we're so short-staffed tonight. So,
Thank you.
It's paused at 4 minutes and 56 seconds. Go ahead.
From hearing the audio on this exhibit 81, do you recall saying that the FBI was present because you were short-staffed?
that is my voice. I don't recall saying it in the moment, but that's my voice.
That is your voice.
That is me talking.
So from your recollection, do you recall being short-staffed at that time?
Yes.
And can you explain what the short-staffed mean as far as at that time, what would short-staffed mean?
That we were just very short on resources with what happened down at the parade route and the mass casualties and the amount of officers it took to secure that location. We were very short on people.
And
People were called in off duty.
You made reference to the short staff being the reason why the FBI was present.
Yes.
Is FBI usually present in the situation of short staffing?
No.
We know what he's trying to get at. He just...
Maybe put that off, or do
yes,
you need it?
I'm sorry.
No, it's okay. I just want to make sure if you needed it, it's up. All right.
Sometimes
Take it
I
down.
forget it's still up there.
Takes two of us.
Yeah. And you made reference to recording the interrogation on your phone, correct?
Yes.
And why would you use your phone to record an interrogation? Especially one of this magnitude.
Because the camera in the room didn't have audio capability.
And were you informed of that? Or let me back up. When were you informed that the camera that was in the room did not have audio?
I don't recall exactly. Prior to the interrogation.
And who were you told by?
Hospital security.
Was that the first time you had ever used that police holding room in that hospital?
No.
So it would be fair to assume that you were aware that that room had cameras.
Yes, I knew it had cameras.
And have you ever conducted an interrogation in that room before that evening?
Interrogation, no, but I'd use the room for other purposes.
So what prompted an interrogation in that room that specific evening?
Well, as I explained in my earlier testimony, the situation down in the downtown area of Waukesha where the mass casualty incident had occurred was very fluid. It was still unfolding at that time. We were learning more and more and more about what occurred. We decided to start the interview at that location to see if you'd be willing to shed light on for us as to what you did or did not know. And again, I'll go back to statements I made earlier. There's a risk inherent with every transport. I didn't know where your ultimate final location was going to be that night, so to now start bouncing you from facility to facility to facility unnecessarily was just something we made the decision not to do.
And at
Which
some
makes
point,
sense, but-
the detainee was moved to the Muskego Police Department, correct?
Yes, you were moved to the Muskego Police Department later in the evening.
And when did you learn that that would be a location that the detainee would be going to?
We made the decision to try to use that location after the first interrogation attempt.
I'm sorry that I didn't hear the last part.
I'm sorry, after the first interrogation attempt.
First interrogation attempt. How would you define attempt?
Well, when we were at Waukesha Memorial Hospital that night in the police holding room that we've discussed, I read you your Miranda rights verbatim from the Waukesha Police Department Miranda statement form. And at that time you indicated you didn't wish to speak with me.
So it would be fair to say that the Fifth Amendment right was exercised at that point.
Right to silence.
Under the Fifth Amendment.
Yeah.
So, acknowledging now the fact that the Fifth Amendment right was invoked not to speak, or as you say, the right to silence, why did you continue to record on your phone?
So we are trained at our police department, when you do an interrogation, the recording is to be left on pretty much until you try to effect transport. So typically what we would do is, if our building hadn't been under construction, and when we'd been able to get you back to our police department, where in that situation we may very well have transported you, just because we would have had a municipal lockup there and we could have held you for the night. But that again was difficult based on the fact that we didn't have that possibility at the time. So if someone's in an interview room and at our police department, we'll leave that, even after the interrogation's over, we'll leave that video running until we come back and remove the individual from that room.
Even once a detainee has invoked their right to silence, you still continue to record? Is that a standard practice of your agency?
Yes, it is, for as long as they remain in the room.
And so when did you start recording?
Are you talking at Washington Memorial Hospital?
Correct.
Prior to you entering the room.
So you started recording before the detainee entered the room, and you said you keep the recording on until they leave the room. So would it be fair to say that there should only be recording while the detainee is in the room?
No.
I mean, it makes sense that they would record even after he says he doesn't want to speak, because this guy, him being the opportunist he is, you know, he's faking a shoulder injury. He's saying that they slammed him. And like, imagine if they didn't have body cam footage of that moment when they arrested him. He could have said anything, you know? So they also have to protect themselves, because when you're dealing with somebody like him, he could just say, oh, when I was in the room, they ganged up on me, they roughed me up, like something like that. He would definitely try an angle like that if they didn't have audio and recording of it. I mean, even if they only had audio, he would still try that angle of they were doing something to me during that time. I don't know.
And you did say for the record that that's standard procedure in your agency.
In regards to the interview rooms at our normal police department, which wasn't available at that time, yes.
Would it be fair to say that you were not at the normal police department?
Yes, however, with the audio, I was still trying to make sure I followed the policy to the best of my ability.
Can you show proof of that policy?
I don't have it.
So it'd be fair to say that there's no way to determine if that truly is policy if it can't be proven.
Objection, argument.
Grounds.
Sustained. As to the form of the question, it's argumentative.
How can that policy be proven?
Objection.
Grounds.
Sustained. On relevance grounds.
Do you know where that procedure is located in your agency rules?
Objection,
Grounds.
relevance.
Sustained.
Grounds for the sustain, Your Honor?
Relevance grounds. Relevance. Not relevant. Next question.
It's not relevant?
Cartoon character.
No. Keep going. We can
Looney
take it up
Tunes.
later outside the presence of the jury at our afternoon break, but for now, keep going.
I follow, Your Honor. I apologize.
Keep going. Okay.
So once the detainee was taken to the Muskego Police Department, that would be a pretty standard police department. Would that be fair to say?
Yes.
And a second interrogation also took place at that police department, correct?
Yes.
Any reason why the first interrogation couldn't take place at the same police department that the second one took place at?
Well, the first interrogation, again, wasn't at a police department. Muskego was utilized as they had a lockup facility, so we interviewed you there.
Around what time was the detainee taken to the Muskego Police Department?
I don't recall the exact time.
And you also stated that another law enforcement
Mr. Brooks,
officer.
I apologize for the interruption, but I just want to make sure my jury is in good shape. If you want to just take a moment to stand. It's a little slow, I think, for them, so we're just going to stand for a minute. Again, my apologies for the interruption.
Oh my God, he is so upset right now. You know he is upset right now.
Anyone on my jury need a break? Are we good? I'd like to keep going. Anyone? Okay. No response to that. They said they're good. All right, we'll sit back down. And again, my apologies, Mr. Brooks. Hopefully you know where you were.
Yeah.
He's asking a bunch of pointless questions. It's tough to follow along with this.
It was another law enforcement officer who actually did the transport of the detainee at that time, correct?
Yes.
And you stated earlier in testimony that you and your partner followed behind that transport. Is that fair to say?
Yes.
And I'm assuming at some point that you will actually strike that. You stated to being present during the booking process into the Muskego Police Department. Is that fair to say?
Yes.
So why couldn't interrogation be conducted at that time, which would have been more ideal, considering that you said there was a lockup. I forgot how you referred to it, but basically like a room that the detainee could be secured.
Well, you had been talking about at that point when we arrived at the facility with you that you hadn't eaten all day, you hadn't slept, so we wanted to give you an opportunity to eat, sleep, clear your mind, and refresh yourself.
And what bearing would that have on interrogation?
Well, I mean, you said you hadn't eaten, you hadn't slept. So I think a person is more focused when they're fed and they're rested. So we wanted to give you the opportunity to do that.
And in your opinion, how would that have affected interrogation?
I'm going to excuse the jury.
This is
right now.
ridiculous.
So if
This
our
is
jury,
just-
you could stand for the jury so I can take up a legal issue, please. All rise.
This is insane. It's one of these moments where it's like he's really just doing this just to argue, which isn't surprising, but still at the same time, it's like, really, this is happening right now? See what Judge Darrell has to say. Man, that was strange. And he was asking the same question. Like, he's saying in the same area with this. He's basically just trying to say they had no right to interrogate him where they did. But it's like...
So I'm going to take up two issues
Why
right now.
not?
One is when I paused earlier and told Mr. Brooks I would allow him to... It was regarding the policies. I want to know, as the proponent of the evidence, why you think that's relevant. And then secondly, the questions I believe that you are asking related to the interrogation, unless you can convince me otherwise, go to a legal issue that this court has already determined. But I'll hear you out on that. I didn't want to make an assumption, but I also didn't want to have you question this witness about what really are legal issues that this court previously addressed regarding the admissibility of the interviews.
Well, to the first one, about the
policy.
policies, that's relevant because I think it should be stated for the record why he left his phone recording after he acknowledged that the Fifth Amendment right to silence had been invoked. At that point, interrogation is supposed to stop completely.
Well, I understand what you're saying from a legal perspective, but that doesn't mean the recording had to stop in and of itself at that point. He did provide an explanation on the record.
His explanation was that it's policy, right?
He answered the question, why do you believe having a specific policy and him testify about the specific policy is relevant to his testimony?
Well, I believe that if that's in fact policy, it should be proven. It should be proven that that's a fact, that is a real policy. For all we know, he could just be saying that it's a policy. And at that point, it makes him continuing to record after the Fifth Amendment had been invoked.
Well, right now, you assume facts that are not in evidence, sir. And so you're the proponent of this testimony through your cross-examination. And so without something more, sir, I don't see where there's relevance as to what the specific policy is.
Can you see what I'm getting at, though, Your Honor? If he's saying that this is a policy of his agency, he should be able to prove that that's policy. Because at that point, if there's no way to know that that is the correct procedure that they use every time, then why?
Again, making a lot of generalizations that I don't think are accurate as to what he said. This is a trial, sir, where the allegations in this case are that you drove through the Christmas parade, right, and caused death and injury to a number of individuals. There's also those other charges related to the bail jumping, the battery, and frankly, his conduct isn't on trial. We're not here about a police misconduct trial. I'm not saying that some of this information might not be relevant to his credibility, things of that nature, but you have to, again, you're the proponent of this. Why do you believe those policies relate to an issue of fact in this case, or otherwise go to your defense?
He just wants to argue.
I believe
That's
that
literally
is
all there is
relevant
to it.
because it can show that at the very minimum, that first interrogation and anything related to it should not be admissible as evidence.
That's a legal determination that I've already raised. Your attorneys represented you at that time. They made a variety of arguments. So to then make this trial about that interrogation, it's not relevant.
I'm not making the whole trial of it.
But the issues are legal issues that this jury will not be asked to answer. I've already ruled on the admissibility. That's a legal determination. So I'm not seeing the relevance to those specific policies, and there is simply no requirement that the state or this witness has to prove those policies. You are representing yourself. Hold on, let me finish. You're representing yourself. I'm not aware of any subpoena that required him to bring those policies with. So that would have been on you if you felt it important to cross-examine him on those policies to require that. I'm not aware of that. Have you done that?
Obviously, it was going to come up.
Did you issue a subpoena ducis tecum to this witness to bring with any of his policies related to interrogation?
How can I do that myself, Your Honor?
Fisher,
how can I do that from a jail
attorney.
cell?
This is
you were given all of those blank subpoena copies, sir.
That's a really good point, too. That's a really good point. He never told her that he was going to have a line of questioning about the policies and all that stuff. So how can he be upset at the fact that he's asking him about the policies and he can't produce it right there before him in this moment? You never gave anyone a heads up. Like, this isn't how... I don't know. The way that he thinks this whole process works, he thinks that he can just catch you in something, and it's like... But a lot of times, people have to be prepped in a way to where they can answer the questions. From what I'm getting, like, I'm talking from a standpoint of, like, just what I've noticed throughout this trial and, like, others that I've just watched in passing and stuff like that. But yeah, you have to kind of give people a heads up about that kind of thing if you want them to produce certain documents, it seems. But he thinks that it's like oh, I got you, you can't do it now, so.
And you could have filled that out in a way for this witness to require. You didn't do that. So
who would have served him?
The state would have. They served your other subpoenas. But be that as it may, that's not what we have here. So I believe that your line of questioning is on a topic that's not relevant to the issues in this case. So I'll give you one more opportunity. Why do you believe that questioning him about the policies are relevant to your case?
Let's hear it.
It's relevant to the case because why would he be recording before people are even in the room and then after?
Well, that's argumentative, sir, so that's not a legal basis.
Once the Fifth Amendment is invoked, interrogation is supposed to stop, period. There's supposed to be no more recording, no more questions asked. That should be the end of the whole interrogation.
These are legal issues that you're trying to raise before the jury. I've already dealt with the admissibility, so you've not provided a legal basis to further question this officer about policies related to the interrogation and the recording. He has answered questions. I gave you some leeway on that, and his answers are before the jury. Certainly you'll be able to argue the meaning of that or the lack thereof during your closing arguments if we get to that point. Let's move on, though, to this issue about why I excused the jury. And again, I believe you're questioning him about legal issues that aren't relevant, but you're the proponent. You want to question him. What's the legal basis you believe I should allow you to continue with that?
What legal basis are you referring to?
I believe you were attempting to elicit information or evidence, testimony from this witness on issues that are not relevant.
Is that referring to the same question?
Not the policies, what I just stopped the testimony for, because I don't want to create issues in front of this jury related to legal issues that are not before them to determine.
And is that referring to the question about the policies?
No. You were asking him, why did you stop? Why did you not question him further? Meaning, why did this detective not question you when you got to the Mesquite Police Department? Why did they wait till the next day? I stopped because I know the law on this area, and I know that when a subject invokes their Fifth Amendment, or when you're a defendant in state, it's the 14th Amendment, but nonetheless, right, and you have rights under the Wisconsin Constitution as well, but that because you only invoked your right to remain silent, they waited to question you until a sufficient amount of time had passed, in addition to the other reasons. I'm not going to let you question him in front of the jury about that specific thing. Or at least I'm cautioning you that I'm stopping it because I don't see where that's relevant, but if you keep pressing him on that, you're going to open up the door to him saying, because I was following the constitutional requirements and giving you a break in the questioning so that I could, get a statement I believe would be admissible later on. That's what I'm trying to avoid.
With all respect, Your Honor, I don't think he would have said that.
My concern was we were headed down that path. So if there's some other reason you want to question him.
The 14th Amendment would have been referring to the having the attorney present?
I'm sorry, say that again?
So you said...
How did he get over to this?
When you stated that you know the law in that area about the Fifth Amendment and the 14th Amendment. What were you referring to on the 14th Amendment?
I'm not going to explain that any further, sir. Let me just ask the state if they see this.
Attorney Bailey, that's exactly what I was getting. Attorney Bailey, that's exactly what I was getting at.
All right, well, you understand it's my job to protect the record, too. So I want to make sure that, all right, so with that understanding that you are questioning this witness about why they didn't take you to Muskego for the first interview? Is that where you're wanting to go with all of this?
That was the question.
All right, well, I might have misunderstood, but in any event, it gave us an opportunity to talk about the other thing, so that's okay.
So is that a fair question to ask then? Because I'm confused now if I'm even allowed to ask that question.
I think part of the issue sometimes, sir, is there's either, sometimes the questions aren't as artfully worded as they could be. I know you're doing your best. I like to look at it this way. Questions that are a sentence at a time, meaning a thought at a time, because then they're not compound, are the easiest for a witness to answer. And when you start bringing in other things, it can be confusing, and then I might not understand, or a party or a witness might not understand what you're asking. So looks like it's one of those situations where I was a bit unclear. It's been clarified. If that's the line of questioning that you are going to go, then that's fine. Then I would allow that. I'm not going to stand in the way of that. If the state objects, I'll obviously that's a different story. Then I'll have to rule on it. But I think we're all on the same page now.
And just for the record, Darrell, I will be objecting. I don't want there to be, just because I think this has been asked and answered. He was taken to Waukesha Memorial Hospital for medical clearance. They want to minimize the number of times that he's transported, and they needed the information sooner rather than later. So I will be objecting as to asked and answered. I just didn't want to, we asked the question that the court suggests, and then I object, and so I do want to put that on the record just so the court's prepared for it.
Understood.
Honestly, these little moments that they have outside of the presence of the jury, it's actually teaching me stuff too, because she just explained how the process goes with how they have to wait a bit. So they asked him if he wanted to speak, and he said he didn't. And so apparently there's a certain amount of time they have to wait. I don't know if it's like this everywhere, but apparently here in Wisconsin, it's like that. So after he said that he didn't want to speak, and they left the recording running, and they came back after a certain amount of time to ask him again. And so that's fair game. They're allowed to do that. And I had no idea.
Why wasn't the first interview conducted at Muskego Police Department had not been answered?
I'm going to let you ask that question. So even if they object, we'll put everyone on notice. So because I think it's reworded a bit differently, so I think it's fair. I'm going to let you ask that. All right? Let's bring the jury back out.
All right. Yeah, but these little behind the scenes moments, I guess you could call them, are very helpful.
Thank you. You have enough water, sir? You have water? Yeah. You have enough?
Run through this one.
All right, we'll make sure there's another one. All right, I can't see behind the monitor. Which got or don't have.
Thank you.
Mm-hmm.
But yeah, I really do appreciate these little behind the scenes moments. Because it's a lot of stuff, like I said, I'm learning from you guys in the comments, which, by the way, I hope you all are doing great. I haven't said that yet. But yeah, it's a lot of things that I've picked up, especially when it came to the objection thing. That was early on in the trial, where he didn't understand the objections, but I also didn't get them. So when she broke it down for him, I was able to pick it up as well. But the thing is, he seemed to never have really understood, especially hearsay. He doesn't really know what that is.
All right, thank you, everyone. Please be seated, and Mr. Brooks, you may continue with your questioning of this witness.
And do you recall why the first interview was not conducted at Muskego Police Department?
Yeah, so in regards to the first
Asked and
interview at
answered.
that point, as I kind of stated in my earlier testimony, we didn't know exactly where you'd end up. Muskego didn't become an option and something we thought of as a final place for you until after the first interrogation was attempted and was over with.
And do you recall if you made that determination yourself, or was it your supervisor or something of that nature?
Objection relevance.
Ground.
As to where they were going to take you?
Yes.
Overruled. The witness may answer.
I discussed it with Detective
That's not what he
Casey.
was getting at. I have a feeling that's not what he was actually
And
getting
at that time, that's when you learned that Muskego police station was a viable location.
Yes, that's the point at which we made the decision.
Had you ever used that police station before in any of your investigations before that evening?
Objection relevance.
Grounds.
Overruled. The witness may answer.
I had not, but when our department first closed, that was given as an option for us, being we didn't have our own municipal lockup.
Am I going crazy, or has he asked this before? This might be something completely different. Like, all of his questions they sound the same, but it sounds like he's asked this at least 40 times or so.
And do you recall around what time you started to conduct the second interrogation?
Yes, 12:11 p.m. on the 22nd.
And do you recall how that interrogation started?
Yes, I explained to you I had more information about the domestic, and that's what I was looking to speak to you about.
Do you recall making a statement that we all know how women can be? They're crazy.
I do.
And what did you mean by that?
It was just additional rapport building that I've talked about in my earlier testimony. Speaking to you on a person-to-person level, quite honestly, it wasn't a judgment I generalized towards all women in the world. It was just wanted you to feel comfortable talking to me as a person. I felt we had rapport. I felt I could tell the night before you were comfortable speaking to me. And it was just a continuation of that.
So it'd be fair to say that comment doesn't reflect your opinion of women.
Correct.
Okay.
Why did you feel that would have been necessary to build a rapport that you stated that you already felt that you had?
Because it was just being relaxed. I was relaxed. I didn't want to make you feel unnecessarily nervous. We had been, talking to each other in the casual conversation from the night before, very civilly, very openly about non-custodial topics. And I was just continuing to go along those lines. It wasn't anything other than to just communicate with you on a stiff level, relaxed level.
And do you feel, would it be fair to say that other comments could have been used to keep the detainee at ease?
Objection vague.
Grounds.
Sustained as to the form of the question.
Was there any other conversational tools you could have used to keep the detainee at ease?
Okay, sorry to pause right here. As soon as they had him in here, I feel like as soon as they started the interrogation, it started with him complaining about Erica. So, I mean, it's kind of understandable why they took that approach, you know. I'm not sure why Darrell wanted to clear up the fact that that's not his opinion, all right, but he's always, you know, we talked about this. For some reason, he helps people in that way. He's like, oh, so this isn't really what you were doing or how you feel, right? But yeah, it's understandable why they took that approach, considering that that's the first thing he talked about. Like, as soon as they sat him down, he's complaining about Erica and just pretty much lying about her the whole time and how much she's hurt him. I don't know, but
Objection. Same.
Grounds.
Overruled. The witness may answer.
Perhaps, maybe.
So it'd be fair to say for the situation, you felt that the conversational tool you used would be more appropriate at that time?
So ask that one more time, please.
You felt that, would it be fair to say that you felt that at that time, the conversational tool that you used would be more appropriate for the situation?
I don't know that I was really thinking about appropriateness. Like I said, I was just conversing you on a normal person-to-person level was my intention at the time.
So it would be fair to say that you assumed that would put the detainee more at ease by starting the conversation with along those lines?
I wanted you to be relaxed. That's not anything that I did just specifically for you, Mr. Brooks. I always want people to be as relaxed as they can be. I want them to feel comfortable to talk to me if they are willing. It doesn't change the fact that ultimately I have to read Miranda. But I always want all the people I talk to feel comfortable and be willing and know that they can talk to me if they want to.
Speaking of Miranda, do you recall reading the Miranda rights in the second interrogation?
Yes, I do.
Do you recall how long into the interrogation before you read the Miranda rights?
Objection.
Grounds.
Objection, misstatement, and mischaracterization of the evidence.
Grounds.
Well, sustained as to the form of the question.
It would be fair to say that the second interrogation was pretty long. Would that be fair to say?
Yes, sir.
Do you recall when in the second interrogation you read the Miranda rights?
Your Honor, I am going to object again to the form of the question. The interrogation began, the court made a finding as to when the interrogation began prior.
I'm going to sustain the objection as to the form of the question. It calls for a legal conclusion. Next question.
Did you immediately start the second interrogation with the reading of Miranda rights?
No, that is not the first thing I stated to you. First, I explained to you what I was wishing to talk to you about.
And do you recall how long you were in that explanation phase of the interrogation?
Maybe around 15 minutes, 16 minutes.
So it'd be fair to say that you didn't read the Miranda rights till somewhere after already interrogating the detainee for 15 minutes at least.
Objection.
Grounds.
Misstatement.
What?
Sustained. Calls for a legal conclusion. Misstates the testimony as well.
You read
That's some slimy stuff.
You read the Miranda rights after 15 minutes.
Yes, thereabouts.
Do you recall why you didn't start the second interrogation with the Miranda rights?
I'm not required to read them immediately, so those first 15 minutes were verifying your personal information, explaining that I now wish to talk to you about a domestic involving your girlfriend, and then I read them before asking you any specific questions about that event.
Would it be fair to say that you had already obtained personal information the night before?
I had, but I didn't have it in front of me, and I have to recomplete the whole Miranda sheet. So I had to refill out the top form of the sheet, which is your name, so I had to verify that.
So it'd be fair to say that you had obtained personal information that you didn't bring with you for the second interrogation?
I did not have your information written down at that point. Yes.
Do
I
you
feel like that
recall
could have been
why
argumentative.
at that time you didn't
Sorry,
have
I
the
thought
personal
you were-
information?
I'll rewind a bit.
I did not have your information written down at that point. Yes.
Do you recall why at that time you didn't have the personal information that you had already obtained?
No.
No, as in
I don't recall why I didn't have it.
That's ridiculous. He tries so hard to spin people up, but he can't do it.
and you said you started off the second interview with information about domestic allegations. That'd be fair to say?
Yes, after reading Miranda, if that's what you're asking.
No, I
You're
didn't.
right. I don't know what are you asking then? Just so I'm clear.
The question was, again, you started off the second interrogation with domestic allegations.
Yes, that was part of the beginning, explaining to you those allegations that had come forward. Things I didn't know about the night before.
Any reason why you wouldn't explain the real reason why the detainee was being detained?
At that point, the domestic was part of the real reason why you were being held in custody.
Did you have any more knowledge about the incident from the previous night at that time?
Are you referencing the parade aspect of it?
Yes.
At that point, yes, I did.
And why wasn't that information given to the detainee at that time?
As I explained in my earlier testimony, the idea behind the second interrogation was I began with the domestic abuse issues, questioned you about those, and then moved into the parade aspect of the investigation.
And why not start with all the information you knew?
Objection, relevance.
Grounds.
Overruled. The witness may answer.
Can you repeat the question, sir?
Okay. It's weird how he thinks this. I mean, we talked about this again. He thinks they're supposed to just tell him everything. And I'm glad they started with the, like the less serious offense. I'm not going to say it's less serious. He put his hands on Erica and stuff. But, like, basically, I'm glad they started off with that and then moved into the parade. Because then they get to see how he is as a person, how he answers questions, if he's truthful, or if he's gonna, which in his case he just lied about everything. So they got to learn the type of person they're dealing with. So why would they tell him everything when he proved that he's not trustworthy? They can't believe a single thing that he's saying. So I don't know. It's just weird how his mind works. He gets to do bad, but if you're also doing something this isn't bad, but he just feels like, oh, you weren't truthful with me, when he wasn't truthful the entire time. It's just weird.
Why would you not start the second interrogation
It's
with
beyond weird.
the information that you knew?
In regards to the parade?
In regards to all the information that you had at the time?
Well, as I stated again in my earlier testimony, as we began the second interrogation, I explained it was about a domestic with your girlfriend, Erica Patterson. But again, I can't give you all the details because part of gauging truthfulness and avoiding I'm not leading you is not telling you every single thing. I had told you she alleged there were physical injuries, but I can't really tell you what they were because I want to see if you're going to be honest and tell me what they were. Additionally, telling you what the injuries were as far as Mr. Patterson could cause you to create a lie to avoid those. And it's the same issue with the parade.
Did you speak to the complainant of the domestic allegations at that time?
Objection. The use of the word complainant.
Sustained is to the form of the question.
Had you spoken with Ms. Patterson about the alleged domestic allegations?
I did not.
So it would be fair to say that you, at that time, didn't know if they were true or not?
No, that wouldn't be fair to say.
And why would that not be fair to say?
Well, hold on. It's for this jury to determine the facts of this case, including the domestic allegations. So I'm not going to let a witness comment on his belief or not on any other witness's testimony or information. Fair enough?
I apologize.
All right. Next question.
Seems he wants to be friendly today.
Had you at any time before the second interrogation spoke with Ms. Patterson?
No.
You made reference, I believe it was in both interrogations, to reading. It was in reference to the Miranda rights, stating that if I was at home on my couch, do you recall making that statement?
Yes.
And what do you mean by that? At home on my couch. What do you mean by that?
I don't know what he's talking
Well,
about.
Miranda is strictly custody based, so I could interrogate you or question you about a matter in which you were a suspect at your home, and I would not be required to read those warnings. Being we were in custody, we were at the Mosquito Police Department. You've been handcuffed, you've been transported. Custody was obvious. I'm required by law, therefore, to read you those rights based on you being in custody.
You made a reference to that's a requirement by law. In custody, you have to read those by law.
Objection. Relevance for this hearing.
I'm going to sustain that objection. I believe it's also been answered. So, next question.
Do you recall if those Miranda readings are to be at the beginning of interrogation?
No, this has been asked and answered.
Why is he
as well.
circled back to
Sustained.
this?
It has. It also
Just
calls for
end the
legal
cross-exam.
conclusion, which is not appropriate. Next question.
I feel like he's run out of questions, but he's just going back and forth now with this.
In the first interrogation, you spoke of the detainee being detained for loitering and prowling. Did you make reference to that in the second interrogation?
No, I did not.
Any reason why?
By the time of the second interrogation, the primary focus had shifted to the domestic incident between yourself and Erica Patterson, and also the parade, because by this point I had more information about the parade and that incident specifically.
So what happened to the initial loitering and prowling allegations? Why were they discarded?
At that point, they were not the primary concern. Eventually, the interrogation came to a stalemate, so to speak, and we didn't discuss it. The primary concern was the domestic issue between you and Ms. Patterson, which at the time I began to start the first interrogation, I didn't know anything about. And then the fact I now had more knowledge on the parade.
So do you recall who made the decision for the loitering and prowling allegations to be discarded?
Your Honor, I think that mischaracterization of the testimony, the fact that it wasn't charged isn't on this officer.
I didn't say anything about it being
That's
charged.
not an evidence, and for the other reasons indicated by the state, I'll sustain the objection.
Just for the record, I didn't say anything about it being charged.
Understood. My ruling stands, even with that.
So would it be fair to say that in both interrogations you gave different reasons why the detainee was being detained?
The explanations that I explained to you did change. However, again, the domestic was not known at the time, so that circumstance changed a bit. That became something that was of importance to us. Domestic abuse is taken seriously. And again, there was more knowledge about the parade.